Hi, everybody. Jean Humbrecht here, criminal and traffic defense attorney in Manassas, Virginia. Welcome to my weekly Facebook Live. Today, I have a very special guest, Shahara Wright, who is joining us all the way from Houston, Texas. Today, Shahara is going to be telling us about intellectual property law, basically an overview of what it is and why it's important. Now, Shahara is joining us from Houston, but due to the type of law that this is, she can actually represent people pretty much throughout the country because it's dealing with federal law. So this webinar will be very informative, I think, for anybody, regardless of where you're tuning in from. And on that note, if you guys want to leave a message in the comments about where you are checking in from, let us know. I'd be curious to see who all is watching today. And if you like it, give us a thumbs up or the wow face or whatever face you want. And also, if you have questions when we're going through this webinar, feel free to type them in the comments and we will try to answer them either during the show or afterwards. And if you're watching the replay later, obviously, feel free to leave a comment and we can try to get back to you later. But right now, I'm going to hand it over to Shahara. Shahara, can you tell everybody a little bit about what it is that you do and what intellectual property law is?
Sure. Thank you so much for having me, Gina. I appreciate it. So again, my name is Shahara Wright. I'm a business law attorney and I work with for-profit and nonprofit organizations and I work with them as general counsel. I've been practicing for 21 years. And 20 of those years, I have owned and operated the Wright firm P.L.L.C, where we worked again with business owners and nonprofit organizations, basically doing day-to-day legal advice for businesses, contracts, formations, licensing, IP, all those different things. We handle a whole lot of different types of law for businesses and nonprofits. So that's just a little bit about our firm and myself. As far as intellectual property goes, it's a very broad topic. Mm-hmm. So I know a lot of times people think, IP, which is what, the acronym for intellectual property, we think, it's really a small topic, but it really is broad. There's almost, little segments and niches within the whole IP community. So there's a lot of different things to talk about. But what most people are familiar with are patents, trademarks, and copyrights, right? They're knowledgeable about those versions of things. So patents, for example, are usually inventions, things that you can have some kind of process, novel. So I'll just kind of use the bicycle, for example, I don't even know who created the bicycle, but whoever came up with the bicycle, put this thing together, created an invention, and therefore, that was something that could be patented, and it lasts for a certain amount of years, your patent does. So that's really what a patent is. Usually some kind of invention, some kind of, it doesn't necessarily have to be a physical process, but it's some kind of process, something that's novel, unique, that's introduced to the world that can be protected for a certain amount of time. That's really what a patent is. A copyright is more artistic. So you're looking at something when people are writers, maybe they're artists and they're doing paintings. Sometimes software codes, the code itself, right? Not the function of the code, but the code, the writing of the code. That's something that could be copyrighted if you wanted to. You can do with music. So in music, you have different levels of what we call the copyright protection. So you have the sheet music itself, right? How the notes are being done. When someone is actually singing it, the performance of it is done, the lyrics. So you can see in music, you may have 4 or 5 different copyrights that are available just from some music. So that's kind of a real simple explanation of a copyright. It's more artistic. And then we have trademarks, and trademarks really have to do with commerce and how something is sold and known by commerce. And really what you're looking at is how the consumer sees or views the product or service. So it has to connect to a product or service, and the connection is something that you see. My favorite example is that of McDonald's, because people understand they have various trademarks, but you understand the word McDonald's. When somebody says that, you automatically think of the hamburger joint. And then when you see those big giant golden arches, exactly where you're going. So it used to be I know laws have changed now, but it used to be you drive long distances and McDonald's would have like those 100-foot signs that you could see from
Hmm.
like 20 miles away. You
Yeah.
knew, okay, hey, there's a McDonald's coming up. I know to drive that way because you understood and knew what that means. And that's really what a trademark does for you. It provides the recognition, and the reason why you know that it exists is because you keep other people from having the right to be able to use something that's similar to that. And then that way, when you keep all your competition away, that becomes the brand recognition of being able to do that. So that's my quick and dirty version of what intellectual property is.
Okay. Well, I'm glad you gave us the quick and dirty version because I actually have a lot of questions. Um, can you can you explain to us, the benefit of actually going through to getting a trademark or a copyright? Because, and the reason I ask is, let's say I write a book and I publish my book. It's on Amazon. People can go online and buy it. It's got my name on it. It's got my picture on it. It's my book. Is that really my book? I mean, what protection do I have just by publishing a book? Why do I need to get that copyrighted, or what is the benefit of doing that?
So the registration on a copyright, so a copyright exists from the time that you create it. So once you create something, you have a copyright, and that just means you have the right to the copy. That's the kind of layman's version of it.
Mhm.
Then you can register it, and the registration is what gives you the legal protection. It kind of gives you the hammer, so to speak, to your nail, to be able to protect what you have created. So what I tell people in terms of copyright, it really kind of depends on what you want to do. Sometimes people just, create stuff and they really don't care who uses it. They're, it's out in the free market. They really don't care about getting recognition or anything like that. They just do stuff, right? Musings, whatever else. And that's fine. You don't have to register it. But if it's something that you want to protect, if you something that you want to keep other people from utilizing, or without giving you credit and those kinds of things, then you definitely want to register it. And it doesn't mean that you have to charge for it or you can't put it out in the open, but the credit in terms of being able to say that it is yours and your original work, really you need to register it. So that could be for a book, that could be for a blog, that could be, again, artist paintings, music, those kinds of things. To make sure that you always have the credit for it, registration is important.
Okay. So basically anything creative, any idea that's yours.
Yeah, it's not just the idea, but it's actually what you have put down, right? Pen to paper, so to speak.
Okay.
So it's not just like an idea in your head, right? You can't copyright
Mhm.
the idea in your head, but once that idea comes from your head onto paper, if it's original,
Mhm.
then that's something that can't be copyrighted.
Okay. And is that something that you have to renew, or once you do it one time, you're done?
So once you do it one time, you're done. It's good for the life of the author. There are some limitations in terms of, how long it can last and things like that. But that's really for the good of the public. The same thing with patents. It really has to do with the good of the public and being able to use for public use. So the whole idea between copyrights and patents, and this is kind of the only similarity, is they're not the same at all. But the only similarity is that the whole idea is that it's good for the public, right? That it's something that could be useful for the public, and has some use. And it doesn't mean it has to be good for everybody, but there's some kind of public use that's going to happen eventually. So which is why they expire, which is why they don't last forever, because it's really not intended necessarily for commercial use, which is that's why it gives you a limited time. So that limited period of time gives you that commercial use where you can use it for a certain amount of time. But then after that, it kind of goes to the free market, because the whole idea is that it's supposed to be there for the public.
Huh. That's interesting. So you have to renew your patent. Well, copyright you said was for the life of the author, but you have to renew your patent and your trademark every so many years.
Yeah, so trademarks are a little bit different. The whole trademarks are intended to be commercial, right? So they
Right.
can they're it's different in that sense that they the whole purpose of a trademark is for commercial use.
Hmm.
So if you're not using it for commercial use, then you can't get a trademark. Whereas patents and copyrights are not necessarily going to be used for commercial use.
Hmm.
So the purpose behind them and why the laws exist are kind of different. So
Okay.
for trademarks, yes, you do have to and renew your registration, but that's really to show that you are in fact using it for a commercial purpose. So those there are differences in terms of why they exist and the reasons behind them.
Okay. All right. Well, that makes sense. Now, you mentioned the example of McDonald's and the Golden Arches, the big M. Everybody knows that's McDonald's, and nobody would use that trademark because everybody already knows it's McDonald's, number one, and number two, they've gone through the process of registering that trademark. Now, there are millions of businesses that are not the size of McDonald's. What would you tell, a small business owner, when should somebody think about pursuing a trademark, because you don't know if you are going to grow the size of McDonald's or remain just a one person shop. So when is it important to start thinking about pursuing a trademark?
I think it's important as soon as you start your business. I think it's the sooner the better, especially now in this climate market. I mean, it used to be a novel thing to have a trademark because you didn't have the internet, you didn't have this way for to be everywhere, and so something again like a McDonald's that was everywhere, because they had physical locations in all 50 states and everything like that. They could do that, and maybe some mom and pop shop wouldn't be seen outside. I'm just going to use Texas because I'm here. Somewhere local to Texas, you wouldn't see or hear of them simply because you didn't have the internet. Well, now with the internet, and if you're doing anything selling stuff digitally, you've got your Facebook presence, you have your social media presence all together. People see you all around now, and so therefore the things that you're doing, your goods, your services, can easily be duplicated without even somebody ever stepping foot in your physical location or not. So then that makes it more important for you to be able to protect it. So I think that you have to think about these things, even from the beginning, and saying, what are we really doing? Now, there are things called state trademarks where sometimes a highly localized business can just do a state trademark and it would be fine, for their purposes, because they're really truly localized and they're not going to be somewhere else. But I think, whether it's a state trademark or a federal trademark, these are something that conversations that you have to have, around branding, around protection, because you want to make sure that it's something that you can create, again, brand recognition, that people know that is true to you, and it's something that's important.
Okay. And based on what you said, I actually thought of another question. Um, and it might sound kind of simple and silly to you, but I think a lot of people might not really understand the importance of, getting this trademark or getting a copyright. What could happen to you or your business if you don't do this? What is the worst case scenario? Well, I don't really want to put it that way, but what kind of situation can you find yourself in where this would protect you?
So, for example, I'm working with a client right now. We're close to getting the registration complete, but they have a networking company, and it's a networking group really, and it's mostly local to the area. But because again of the internet and because people are seeing it and using Facebook and LinkedIn and all that kind of stuff, it appears to be bigger than probably what it is. But it's been going on for a long time. Now they looked at doing a trademark probably about 3 years ago, decided against it because they were using another service, and the service kind of made a mistake of saying that they couldn't trademark it. And lo and behold, 3 years after that, there was another company that trademarked a name that was very similar to this name. And my client got a cease and desist letter. We went ahead and filed for the trademark. And then when we filed for the trademark, we realized there were 3 other organizations that had filed for a similar name that within, mind you, within the time period that my client had been told, not to register it. So like in 2017, they were saying, oh, you couldn't register it. And then from between 2017 and 2019, when we actually filed the registration, 3 other companies filed for a similar name. So now that we're filing, now we're having to, it's going to cost more, number one, because not just the filing, but you're having to argue about who has the right to register it, who had the first use, the classes that you're going to be in. All of those different things have come along with a fight, and trying to get it long and costing more money because it wasn't done in 2017 when probably nobody at that time had filed for registration on using this name. But ever since then, people have been filing. So these are the things that can happen when you don't do it right away, or you don't do it when you wait, or just think, oh, it's not a big deal. And again, it's because of the advent of the internet. It's because people are seeing things and having access to things that they probably wouldn't have before. So like I said, my client is a highly localized organization, but because we have a presence on social media, because we have a presence there, it can be confusing between company A and company B to the average person. They don't know what the difference is. And if before the internet, it wouldn't have mattered because my client would have just been in one place and nobody would have known. But now we definitely have to protect the image and the name and the branding, because you don't want people to be confused between company A and company B.
Well, that makes sense. I'm thinking a lot of questions right now. So somebody does not protect their trademark, and then when they go to register the name or whatever, then they could run into problems if other people have already registered a trademark under that name, correct?
Yes.
Okay. So is it your name that the trademark protects? Can you just explain a little bit about like what it is exactly that trademark protects? Because you said that you represented a networking group and somebody else tried to use the name. Was that another networking group that tried to use a similar name?
Yes.
Okay. So is it the name and what they do? I mean, or, what if you have 2 companies with the same name, but they do totally different things?
So it's a kind of a combination of things. It's not really a simple answer, but I'm going to try to make it as basic as possible.
Okay.
So let's just say we have company A and company B, right? And, you have these, they're in the same exact niche, and we have, well, let me back up. There's classes, right? There's 46 different classes of trademarks. Those covers goods and services. So you have to register in each class. So what will happen is you have company A and company B that have similar names. And if you register in the same class, you'll get what we call a 2D action, which is a likelihood of confusion. And the attorney will come back and say, the USPTO attorney will come back and say, hey, these 2 names are similar. It can likely confuse the consumer, right? Because they're always looking at it from the consumer point of view, right? It can confuse this consumer. So now you have to explain to UPTSO why, one, that it wouldn't be confusing, why they're different, how they're different, why the consumer wouldn't be confused. If, the examining attorney looks at it and says, oh, okay, I see how it's different, you might can get it through. But if they look at it and say, no, it's exactly the same thing, then you're not going to get it through. Another part of that is that even if the examining attorney doesn't feel like it is the same, then you can still get an opposition from company B that says, hey, this is confusing. I oppose, this application because it would definitely infringe upon, what we do, and you can have that opposition there. So there's kinds of ways where you can have this stumbling block that happens in there. It doesn't necessarily have to be in class. Sometimes that's just kind of the best explanation, right? When they're 2 very similar, but it doesn't always have to be the same class. Sometimes it's not the same class, and you still have to provide that same explanation, right? One may be selling dishes, plates. The other one may be selling glassware. And so they may actually be in different classes, but dishes and glassware are so similar that therefore, there could be some confusion as to who is actually, selling which one, which brand is representing one. So these are just kind of some examples about how the confusion can come in terms of what the consumer sees and recognizes where they can be so similar.
Okay. Okay. Well, that makes sense. Now, I guess that goes back to what you were saying before, that companies and business owners should start thinking about this when they first start their company, because, if the company name that you create, like say you want to use your name on everything, and then whatever it is that you come up with that you want to trademark, and it's under your name, and you go to register that and it already exists, that's when you're going to hit a problem, right?
Yes, exactly. And it may not even be registered. Sometimes brands are not registered, but they've been out there operating for a really long time. So you haven't done a search, you do all of this branding, you try to go to register it, and you realize there's another company that's been operating for 20 years longer than you that has this, and now you've got a problem. So those are things that can happen. So the sooner you look at it, I think that anytime when you're talking about branding, right, not just fonts and colors, which are important, but I mean, it becomes before that. Branding really has to do with name recognition. It has to do with being able to say, I see this and I understand and know what it is and what it goes to. And so therefore, having the registration, the trademark registration, prevents other people from having anything similar so that it doesn't create confusion.
Okay. Now, when back to the McDonald's example and the golden arches, that is that what we would call a logo?
The arches are a logo, yes.
Okay. So, can you explain to people the difference, if there is one, between a logo? Are you trademarking the logo, or is the logo just a part of what you're registering a trademark for?
So there's going to be two different types of applications. One is called a word mark, which would be the words McDonald's. The other one would be a symbol, which would be the logo, the golden M. And the symbol can either be recognized in color or just be an M without color. McDonald's has theirs as yellow, so that you know that it exists there, so you don't see it in different colors. But you can kind of do. I usually do black and white marks, because you never know when somebody's going to try to change the color and things like that. But it's the mark itself, in terms of the symbol, that's kind of the logo, or something that you see or hear that recognizes, what it is. But the word mark is there. So those are two completely different applications. You can't combine them.
Okay, so it would be the same process, but you have to do two separate applications, two separate trademark registrations.
Yes.
Okay. And then another question that I was thinking of, when you start your business, and I kind of alluded to this earlier, you might not have any idea where your business is going to go. You might not have any idea that something is going to be successful, that somebody might want to steal or take or use or misappropriate something that you do, in the future. So, how do you best protect yourself if you don't have, a clear plan, or if you're still trying to figure out what your brand is?
Well, I think, in terms of trying to figure out what your brand is and what your name is and your logo, obviously you don't want to register something that could change in the next 6 months or whatever. That would be a waste of money and resources. So obviously you have to get to a point to where you kind of know, okay, we're going with this, we're running with this, and this is what it is, and protect it as much as you can. So that's important. Obviously, starting a business is a risk. There's all kinds of risks that go, again, with starting a business. You never obviously know what's going to happen. I don't think that your decision about registering a trademark should go with, do I know it's going to be successful or not, right? Because when you rent an office, you get phone lines, you do any other expenditures, you don't ever really know if it's going to take off or not, but you go for it anyway, with putting those expenditures. So I think in terms of trademarks, that whole concept should be a part of that. I will say, in terms of money, and I believe this wholeheartedly, that a trademark is only as good as your willingness to protect it. So if you are really kind of budgeting and trying to figure out what you're going to do and all that kind of stuff, paying for a trademark, no matter what service you use, is only going to be as good as your willingness to send cease and desist letters, to file suit against other people, those kinds of things to ensure that that doesn't happen. Another large organization, really, like, I'm using large organizations because people understand and they recognize it, right? So it's wildly easy. But another one is Disney, right? Disney, with their copyrights, do not play around. It doesn't matter whether you're a school, a kids play, some large company. When it comes to their stuff, you will get a cease and desist letter. They are very, very, very aggressive. And I'm not saying that you have to be Disney level aggressive, but you do have to be aggressive when it comes to protecting your stuff, because if you don't, and other people are just using it or doing whatever, then you lose your rights. You no longer have this distinctiveness that comes with your brand. So if you're allowing other people to have something similar, then it kind of water down the protection. You really can't really claim it for one and not for the other. You're going to have to do it all. So it's really only as good as your willingness to protect it. And if you don't have the financial resources to protect it, then I really would consider whether or not you want to do it in the first place. Because I see a lot of people who will pay for trademarks. They may go to LegalZoom or some other service because it's inexpensive. And then when they get, when they see other people infringing upon their brands, they don't have the money or the resources to go after those people. Well, then what's the point of your trademark? Because if you're not going to do that, it really isn't doing you any good.
Mm-hmm. Yeah, that's a really good point, because the whole point is to protect it. And if somebody is not listening to those cease and desist letters, then you can take them to court, and
Right.
you have that registration and everything as backup or as a defense, or not really a defense, an offense in your case. But yeah,
Mm-hmm.
if you're not willing to go to court, yeah, that makes sense. So people do need to think about that. Okay, well, you had mentioned earlier that you basically you're a business attorney and you work as general counsel sometimes for small businesses and nonprofits, and you help with the incorporation, right? Getting a business started. Did you say that too?
Yeah, so we do the incorporation. So a lot of my practice is working with existing businesses. So a
Hmm.
lot of times with my clients, they may have been operating for a significant amount of time and have not done their formations. They may be still operating as a solo, or a sole proprietorship. Sometimes, we have one form, but they're looking at expanding. So we need to create, subsidiaries or secondary businesses. I work with a lot of serial entrepreneurs.
Hmm.
So we have multiple businesses. So a lot of the work that I do, especially in terms of formations, really has to do with kind of restructuring businesses to ensure, fit for growth, ongoing growth.
Okay. So in doing that, do you do you approach all of this kind of at the same time, deciding which way to incorporate, whether to become a corporation or a partnership, and then you also talk about the branding and the trademark issue and any copyright issues that there might be. Do you handle all that together sometimes?
Sometimes, a lot of times, and I know this, Gina, as an attorney, that people don't come to you with always the whole story. Um, so you get bits and pieces of it, and it's the same thing for me, right? Like sometimes people will just say, "Hey, we need to incorporate." My accountant said we need to get an LLC, or my accountant says we need to do a C corp, and then we do a C corp, and then I find out more information. I'm like, hey, while you're doing this, you might want to do such and such and such. So, it just really depends upon how. I don't necessarily do it all at one time, but
Mhm.
I do think, these things come down the pipe where, these are things that have to be done because, over time, I'm learning and seeing more of the business operations that these are things that need to be done.
Okay. Yeah, that's a good point. Yeah, because you're not going to know everything all at the same time, or something might come up later. But what would be, and something I should have said in the beginning, a conversation between two attorneys, this webinar is for informational purposes and is not legal advice. So if you have questions, definitely, seek out Shahara if your question is involving intellectual property or business law, or another attorney. This is just informational purposes, and everybody's situation is different. And I'm sure, Shahara, you can say the same thing. I mean, you probably have never represented any two clients that had exactly the same
Yeah.
problems or situations. So yeah.
Right, exactly. It's always different, and I think, and especially with law, everything is situational. And so you have to kind of look at it and see what the situation is to see if it applies to you and what you're doing.
Hmm. Now, what would be the one piece of advice, if you can make it one piece, that you would give to a business owner or anyone who is trying to decide whether they should pursue protecting their intellectual property, whether that be a trademark or anything, because and the reason why I'm asking is a person might not know if they should even pursue this. So when should a person, in what's, I need to be more concise, in what situation should a person really sit down and think about this or consult with an intellectual property attorney?
So I think, one of the things that I personally believe in, right? Like, so every attorney is probably business law attorney or intellectual property attorney is probably going to feel a different way. But I personally believe in looking at the company as a whole. And I personally believe in looking at what you're doing. So if you're working with a marketing person or, a branding person or somebody that's kind of, trying to determine how the company is going to go forward marketing wise, I think having a conversation with that person and attorney would be good, because I think those go hand in hand. So sometimes people will come to me and say they're thinking about trademark, and they want to protect their stuff, and we'll have a conversation, and I'm like, you're not at that stage yet, right? Because you still don't have these certain things together. And if you go ahead and do a trademark now, it may change in 6 months, or this may not just be the best time because you don't have it kind of put down. So
Mhm.
I think kind of knowing where you're going, knowing that this is going to be the direction that you're going, at least for some time, is important. I mean, obviously people rebrand, things happen, but a lot of times I will find, especially with smaller businesses, that they rebrand often. And it becomes kind of pointless when you've paid all this money for a trademark, and then you try to rebrand with a new name and a new logo and all that kind of stuff. So I think that there's, to some degree, you need to kind of know who you are, not to say it's going to be perfect, but you got to know who you are and what you're going to be. And if there's some indecisiveness in that, then trying to do a trademark, I think, might be a waste of resources. So I think you should do it as soon as possible, but I think you need to have clarity about what your brand is and the direction that it's going prior to doing it.
Okay, that's a really good point, and it actually led me to another question, but I'll stop after this because I could just go all day long. Um, so let's say you have a plan, at whatever it is, you pursue the trademark, the registration, you do that, and you're not changing the name of your company, you're not changing the service that you provide, but maybe you're changing your message, like maybe your tagline, your elevator pitch, something within your business is different or additional. Do you need to redo the trademark at that point? At what point do you need to register again because it's so different?
So I think it just depends on whether or not the rebranding leaves you within the same class. So what you say. So in your trademark application, a couple of things happen. So you'll recognize your particular class. So let's just say I'm going to use class 41, which is usually, for most coaches, end up in class 41. So that's a broad category for education. So maybe your next first, and then you have to kind of drill down within that. with these subcategories, and the education may be for children's programs, and the education may be for books and booklets and things like that. So even if the messaging is changed and you're still doing children programs and you're still doing books, or you're still doing, whatever you're doing within that class, then it's not a big deal. But if the rebranding takes you to something completely different, so let's now just say that you're doing YouTube videos, and now you're doing trainings, and now you're doing a whole bunch of different stuff, and it takes you out of that class, then yes, you're going to need to register for the class that you need to do. So it really depends upon the nature of the rebranding. Sometimes rebranding is just, again, like you said, messaging, very simple, but what you do is the same. Sometimes rebranding is, not really even rebranding. You kind of throwing out the whole business and starting over, and that's something that has to be dealt with for sure. And then sometimes people add services. So a lot of times, people will come up with a whole new service, a new thing that they're doing, and so you're not registered in those classes, and you need to register, in those classes too, to have the protection.
Oh, okay. So sometimes it could just be adding additional class, like, okay.
Mm-hmm.
Okay.
Yes.
Okay. All right. Well, yeah, that actually clarified a lot. I learned a lot. And by the way, to all those watching, every area of law is so vastly different. I do criminal and traffic defense, and Shahara does business law and intellectual property. Not similar at all. So I don't even think I took an intellectual property class in law school. So
Well, I can tell you now, I don't know anything about traffic defense, and I always hire someone. When I get a ticket, I'm like, hey, somebody needs to help me, because I don't know anything. So yes, they are so different. And just because, it's kind of like how doctors are like, hey, one's a brain surgeon and somebody's asking you to look at a boil on their foot, and they're like, I don't know what that is. Yeah.
I
So
know. Yeah, yeah. So yeah, so I learned a lot. I'm sure everybody watching this did too. And like I said, if you have any questions, type them in the comments, and we'll try to get back to you at some point. And I think Shahara and I are going to be doing more of these. So look for a series. We're maybe going to get into more specific topics. Maybe talk about copyright, specifically trademark, maybe some business law, because Shahara is the expert with that stuff. So stay tuned for future videos. So thank you guys all for tuning in. Thank you, Shahara, very much for joining me today. I really appreciate your time and all the information.
it was fun, Jean. I look forward to doing the next one.
All right, I'll see you later.
All right, bye.
Bye.